Hello, everybody. Welcome to this plenary session, which is titled Current Governance Settings and Challenges for ADM and ADI and AI Governance. I'd like to acknowledge that we are on the lands of the Turrbal and Yagara peoples. My name's Damien Carrick and I present the Law Report, which is the weekly current affairs program on ABC Radio National. And it's my great pleasure today to be facilitating this conversation and letting you know that it is being recorded for future broadcast on ABC Radio National. Now, today we will be having a conversation between our panel members for about an hour, and after that we're going to open up to your questions and comments. No doubt the conversation will spark a lot of thoughts with you, but please do keep them until that last half hour, and we will have a roving mic. The Australian government is rapidly developing and installing new guidelines, regulatory frameworks and laws to better guide the development of automated decision-making and AI across government operations, policy-making and service delivery. These initiatives are in response to the challenges exposed by digital government failures as exemplified by Robodebt, also by the new opportunities and risks associated with generative AI and also AI governance developments internationally. So how well is Australia travelling? Will these initiatives build a better, safer, more efficient and more just society? I'm joined today by a terrific group of panellists. We have Kate Allingham, CEO of Economic Justice Australia, the peak body of community legal centres providing advice on social security issues and rights. We also have Emeritus Law Professor Terry Carney. He's a former member of the AAT, the Administrative Appeals Tribunal, and he played a very significant role in alerting Australia to the Robodebt disaster. We also have Dr. Alexandra Sinclair. She was recently appointed as a postdoctoral fellow at the University of Sydney, and before that she worked at the Public Law Project in the UK. And we also have University of Sydney Law Professor Kimberly Weatherall, a former government advisor or former AI government advisory group member. Now, Kim, if I can start with you, we hear about AI all the time, about how all the exciting new things it can do, but we hear much less about how government is or isn't actually using AI in its own operations. What do we actually know, Kim, about how government in Australia uses AI decision-making?
The short answer to that is not enough. We don't know enough. It's because the governments often don't tell us everything about what they're doing in terms of the adoption of AI and automated decision-making. There's certainly a lot going on. We actually at ADM+S, we did a study, one of the most comprehensive attempts to map use of ADM and AI across government, actually focused on New South Wales. And what we found is that it is everywhere, right? There's automation everywhere. It can be everything from the really convenient things like automated driver's license renewals, or it can be systems for tracking racing greyhounds. You'll see AI in the cameras that detect, the drivers who are using the mobile phones, or systems to identify feral animals, or systems to triage emergency calls. And some of these uses are terrific, right? The systems that detect feral animals so that people know where to go to deal with that problem is terrific. Some of it is much more controversial. So we found in New South Wales, the Department of Communities and Justice is using automated systems to, for example, triage inmates in prisons. So, it ranges from the really great, really obviously good to the, must get it right, must be really careful about it, systems like the emergency triage systems, right through to controversial, you'd really want to make sure that that's being done well. The message we're hearing from government is actually very keen to use more, right? Particularly this year, I think we've heard a lot of messages about, the need to lean into AI, need to adopt more for efficiencies or for better services. But, again, to come back to your question, we don't know enough.
And there was a New South Wales Ombudsman's report, wasn't there, which tried to sketch out or identify how it was being used.
Well, that's exactly right. And that was based on that research that we did. So, and that actually produced a whole compendium of systems. So we actually got a bit of a picture of what is going on. Not a complete picture. Not every part of government was willing to talk to us. The police weren't willing to talk to us, for example. Well, they're not under Ombudsman jurisdiction, and they have their own reasons for wanting to keep some of their systems less well known. There's no, the key point is there's no central register, right? There's no government register of automated systems. There's no government register of AI systems where you can go and say, there's this thing going on in immigration. I'd like to know how they're using the technology.
So there's a lot we don't know. Kate, should we be worried about current government use of automation or AI? What are the risks that you wish people were thinking about more?
Well, the biggest risk in Social Security is that people end up having their payments cancelled, suspended or reduced due to unlawful practices. The real life consequence of that is people becoming homeless, not being able to put food on the table, not being able to pay for their basic needs. We have seen this happen with automation before. So in January last year, it was revealed that there was a significant glitch in the targeted compliance framework, which is the framework that I guess governs people who are in job seeker who have to do mutual obligation requirements. And a coding error resulted in 1,625 payment penalties that were applied to 1,165 people. So for some people, these penalties occurred to them more than once.
So they were knocked off benefits.
So it's confusing. So they weren't completely knocked off payments. Some of them would have had their payments. The worst case scenario is payments completely cancelled and then having to reapply, or that their payments were reduced.
And why were those defective cancellation decisions made? Was it because the algorithm, they answered questions or the information was processed in such a way as to say these people are in breach?
So it was a coding error that kept people in penalty zone for a longer period of time. The system is really complex, but basically if you receive a certain amount of demerit points, you get put into a penalty zone. After 91 days, that penalty zone ends and you go back into the green zone. And this coding error was keeping people in that penalty zone for extended periods of time, meaning that they are at significantly higher risk. The government acknowledged it. They knew about this for 3 years before anything was done about it. And they were finally compensated, but except for 10 people who died before they received compensation.
So let me get this straight. The information collected by the algorithm was putting people into the red zone when they shouldn't have been there.
It was keeping them, for extended periods of time.
And these are people with complex lives, right? So they might have, maybe the algorithms can't pick up what isn't being asked.
So one of the, I guess, key risks of automation is that automated processes cannot pick up the complexity or would struggle to pick up the complexity of people's lives. And Social Security legislation is drafted in a way that discretion is applied in certain circumstances. So, for example, if someone is victim of family violence or coercive control, they're not going to, or generally will not, walk in and say, I'm a victim of family violence. Often it's more what they don't say. And that training is and that human interaction is something that's really necessary. And other, I guess, areas in terms of where we see this is a real issue, there's issues around an understanding for people in remote locations and the implications for that. There's cultural communication. So Social Security is full of really technical language, like what does the care of a child mean? What is a reasonable excuse for not keeping with your mutual obligations? That would have different, people have different levels of understanding of that. And the automated systems, I would say, would be less able to pick up when someone is in crisis, to refer them to a social worker when they need to be, to suggest that they go on crisis payment. There's a whole range of examples.
So algorithms are not well equipped to deal with the realities of people's lives. Alex, what do we know? Well, we know that Australian governments aren't alone either in wanting to use automation or having scandals erupt when things go wildly wrong. Can you tell us about where automation has gone really badly wrong in other places, in other jurisdictions?
Yeah, I think it's important to kind of situate Australia's automation in kind of a broader context, and that is kind of this context of digitization, both in the global north and global south by governments. And that's this real post-austerity drive for governments to do more with less. And then we're kind of seeing, when those systems are implemented too quickly, some real issues arising. So you might have heard about 5 years ago in the Netherlands, and this actually drew quite a lot of attention because the Dutch Prime Minister resigned as a result. But there was a child benefit scandal in the Netherlands where a automated kind of risk profiling system was generating risk scores for individuals, and that output was used by officials to reclaim all of the child benefits who had been paid to about 27,000 individuals. So they were forced immediately to repay back all of the child benefits they had received, and many of these families were left utterly destitute as a result. It turned out the system had an over 90% false positive rate, and that was something that not even the administrators who were using these risk scores knew at the time that they were using them.
And what was wrong with the system which wrongly targeted these people? And I believe most of them, or many of them, were migrants, weren't they?
Many of them had a second nationality. They were Dutch nationals, but they also had a second nationality. And so the system was using second nationality as a proxy for an individual who might commit benefit fraud. So the system was kind of generating almost entirely spurious risk profiles based on a number of factors, including second nationality.
Okay, so it was a kind of a racialized result. Basically, people were being discriminated against. The algorithm was discriminated against people.
Absolutely. And also it was entirely irrational in the ways that it was operating. It wasn't kind of linked to any criteria that necessarily you would say were probative of committing benefit fraud.
And there was also an experience also in the UK involving authorities trying to identify if somebody was in a sham marriage or not. What was the issue there?
That tool is still ongoing. It's still operating to this day in the Home Office. So whenever a UK and a non-UK national wish to marry in the UK, they have to apply for permission to marry. And there's about 20,000 of those applications a year. And so what the Home Office does is they feed all of those applications through an automated, it's a random forest machine learning algorithm called the sham marriage triage tool, and that identifies which couples should be investigated as being in a sham marriage. And so about 1,500 couples a year are flagged by that system as being in a potential sham marriage. When I worked for the Public Law Project, we were trying to get more information about this system, and so we sought the equalities impact assessment of the system, and it showed us that, for example, Greek, Bulgarian, Romanian, Albanian individuals were being flagged at a much higher rate than their proportion in the population, which made us wonder, well, what's the criteria that this tool is using? Is there a reason why these nationalities are being flagged at such a high rate? So we brought a claim against the Home Office, a Freedom of Information tribunal hearing, to try and find out what those criteria were. We managed to find out 2 of them. One of them is the age gap between couples. So if there's a 15-year age gap, the Home Office thinks you're more likely to be in a sham marriage. The other criteria, quite strange, was the number of trips overseas you've been on. So the more times it had flagged you as going overseas as a couple, the more legitimate the algorithm deemed your relationship.
If you travel together.
If you travel together, exactly. But there's another 6 criteria that we still do not know to this day. The Home Office said that if they were disclosed, the public would game the algorithm, so to speak. and the first tier and upper tribunal upheld that decision. So it's still operating, but we still don't know which criteria it's using or why we're having these disproportionate results.
Okay, so the Netherlands, the UK, here in Australia, Terry Carney, you are at the heart of a lot of the discussions around robo-debt. Do the risks we've been discussing sound similar to you? And can you remind us of the tragedy that was robo-debt very briefly?
Yes, they very much remind me of the robo-debt features, particularly Alex's example, the large-scale, high-speed, heavy detrimental impact on very vulnerable populations. So to remind people about robo-debt, it applied income averaging from tax office records, helter-skelter basically, to the fortnight by fortnight basis upon which working age people's benefits were calculated, and it raised retrospective debts automated against people without any human involvement against, as it turned out, nearly 800,000, 794,000 individuals. And those individuals faced over 500,000 deaths, 526,000 deaths. And the total volume of those mathematically unsound, unethical, and legally completely unsound decisions over that 3.5 years of operation raised, as the government really intended it to, $1.7 billion worth of false debt that had to be repaid. So
From the most vulnerable
scale
Australians.
is the issue. And so the other statistic that's important is that the human system pre-robo-debt raised debts fairly accurately and lawfully against 20,000 people a year. Robo-debt was raising them at its peak at 20,000 a week.
And there was a terrible human toll there, you know.
Terrible human toll. People, Robo-Debt Royal Commission, Catherine Holmes, former Chief Justice here in Queensland, found that a number of individuals committed suicide as a consequence, she found, of the often very substantial, because these debts were sometimes $10,000 to $20,000, out of the blue, with the only option that the person was confronted with being to go on to the online system and lodge the non-existent pay slips or other records from 7 or so years previously. There was not even, and it was a deliberate bit of psychology, the early letters that they got deliberately omitted any telephone, email or other contact. Why? Well, they wanted to compel people to use the automated system with all the savings that came to that on the government side, rather than the more expensive conversation with a public servant who would be able to understand the issue they were raising.
So robo-debt, thank goodness now, is in the past. And we've had that Royal Commission. But let's talk about, but that's very much an example of what can happen when AI and automated decision-making goes terribly, terribly wrong. Kate, when automation goes wrong and people are thrown off benefits, like the example you just gave us, what options do people have now to reverse these decisions or to seek legal redress?
Well, in the example I just gave you, it involved 1,165 people. And of those people impacted, of which some people impacted more than once, not a single one of them made a complaint about the adverse decision made against them. And
why?
This is a really significant issue. People are thrown straight away into crisis if your payment is suspended. All the focus is purely on getting back on payment. There's not necessarily recognition that that there's been a breach of legal rights and that people should be going and trying to get independent legal advice. In terms of looking at the system of why it is that they've been thrown off, our member centres who specialise in social security law rarely see people impacted by mutual obligations. And the time that they do see them is when they've been on this merry-go-round of being suspended, having their payments reduced, cancelled, getting put back on payment again and again until they're so exhausted by the system that they are no longer receiving payments, and they are presenting at centres with legal issues related to homelessness or other legal issues related to poverty.
Okay, so it's a cycle downwards. Alex, in the UK, there are more legal remedies available to individuals than in Australia. Can you tell us about some of those?
Yeah, I think it's fair to say that Australia has some of the fewest options for individuals wanting to bring a legal claim against the government for government automation. So, for example, in the UK, there's the ability for an individual to challenge the entire decision-making system if that system is repeatedly leading to downstream unfairness. In Australia, you can only challenge that individual decision, which doesn't make a lot of sense if you've got a system operating at scale that's repeatedly making unfair decisions. So that's kind of one of these remedy gaps. Another is that the UK has something called the public sector equality duty. And what that means is anytime the government imposes a policy or a system, they have to do an assessment of how that affects individuals with protected characteristics. So race, gender, disability, and there's a whole list. And so anyone where they think the government has failed to carry out this equality assessment, they have a legal right to sue the government. And so one of probably the most well-known cases in the UK, Bridges and South Wales Police, which was a challenge to the South Wales Police's use of facial recognition technology, that was a public sector equality duty case. So what happened there was that Liberty, which is a human rights organisation in the UK, they said South Wales Police, well, actually, I should explain what happens with facial recognition systems. So generally, it's known that facial recognition systems can be notoriously unreliable at identifying women and people of color, because if you don't have a representative training data set, then it's going to perform more poorly on those groups. The London Metropolitan Police was implementing one that had a 96% false positive rate at one stage. So Liberty brought a claim against South Wales Police and said, well, can you show us your data set? Can you tell us, you were under this public sector equality duty to consider protected characteristics. Can you show us this data set? Show us it's a representative data set. And South Wales Police said, well, no, we can't. We bought the system off the shelf. We bought it from Northgate Public Services, and they've told us that it's trade secrecy protected. The data set's commercially confident in commercial confidence, and no, we can't tell you if it's a representative data set. We've never seen the data set. And the Court of Appeal said, well, that's not good enough. Your duty isn't delegable. You have a duty to know the effects on individuals when you implement such a system. But no right like that exists in Australia at present.
Okay, so we've been learning about what some of the problems are. Kim, in its last term, the Albanese government talked a lot about safe and responsible AI, and it ran a number of consultations. I believe you were part of them, I think. Can you tell us where Australia is in terms of its laws around the safe and responsible use of AI?
Holding pattern. Look, you're absolutely right. We had a whole series of consultations over the course of, the last year and a half or so. The government, had a discussion paper on safe and responsible AI and what kind of regulatory system we should have. And lots of people made submissions, and then they appointed a temporary expert group. And yes, I was a member, and we were tasked with helping design mandatory guardrails to ensure that AI was used responsibly. And if you'd asked me this question at the end of last year, which is, where are we going or where are we at, I would have said, well, I'm kind of expecting that we'll get some kind of law with some kind of mandatory guardrails, exact details to be determined, but we were on a path to a kind of system for, putting in place procedures and requirements so that when people are developing the systems, when they're deploying them and after they've deployed them, as they are operating in the real world. It's being done carefully, it's being done with good quality data, it's being tested for things like bias and fairness. You've got governance systems in place, you've got transparency, you've got contestability, all of these things that we really need from these systems. But that was the last term of the Albanese government, and it's unclear where they're going now, because we haven't had an announcement post-election of what plans they might have to follow any of that up. Separately, I should say, so that's AI, safe and responsible AI, and then separately we've had a consultation around automated decision-making in government, a response to the Robodebt Royal Commission. Again, we had the consultation, it's unclear where things are going from there. So we haven't had law reform in recent times. What we do have is governments in particular, and parts of governments, departments within governments, have been developing, assessment frameworks, for internal use, so that they can take their systems through a series of checks to try and make sure they operate properly, which is positive. And it's good that they should do this carefully and have some guidelines for doing that. One of the problems, of course, with that, if we're worried about the kinds of problems that we've been talking about so far, is that, an internal guideline or assessment framework of a government doesn't give anyone else outside a right to challenge, if those guidelines haven't been followed. If the framework hasn't been followed, we have no right to challenge that. So, that kind of process that we're getting at the moment isn't leading us towards legal solutions. And of course, sitting against all of this year, and I think one of the reasons we're in a holding pattern now is, the ground has really shifted. In the last 6 months, the kind of last year, all of the discussion was around safe and responsible AI. This year, it feels like since February, since the Paris AI Action Summit, and all of the talk is around, we need the innovation, we need to lean in, we need the efficiencies that these systems can bring, which has horrible, reminiscences about what led to Robodebt was the desire for savings. We're hearing a lot about how we absolutely need to be working towards more use of AI. We have the US pursuing AI dominance. We have a bit of a discussion about walkback of the EU rules. So it feels like the pendulum has shifted. So I can't tell you right now where I think we're going, but I really hope we do something.
Terry, you've been just nodding furiously as Kim talked about, where we're not going and what the pressures are on governments. What's your response?
Yes, I mean, my two colleagues have very eloquently nailed the fundamentals. And the reason that this is important, particularly, I guess, in light of the splendid report of the Holmes Royal Commission, is that...
The Robodebt Royal Commission, yep.
Robodebt Royal Commission, yes. Was that it hitched on some very strong systemic inquiry, reporting and referral provisions whenever the new tribunal, the Administrative Review Tribunal, replacing the old AAT, Administrative, etc., Tribunal, whenever it identified and corrected an individual error that had systemic ramifications. Now, the only good thing to come out of Robodebt was that we discovered internationally for the first time what proportion of wrong decisions get to go into external review. Now, Australia has one of the most accessible, no fees in social security, no special procedure for a person who thinks that a wrong decision has been made about their social security to go to the new tribunal. But what we've never known is how many decisions were erroneous. Well, we do now know. I gave you those figures a minute ago. And when you calculate the number that actually got to the AAT in the 3.5 years against the number of errors, It's only 1 in every 2,000. I'll repeat that. Only 1 in every 2,000 palpable, undisputed errors with enormous consequences, leading some people to commit suicide, as we've already discussed, got to the external tribunal. So it's kind of as rare as hen's teeth, really, that the systemic reforms that are splendid that the Robodebt Royal Commission recommended and that government has put in place, which allow the President to refer, and President's already referred the apportionment debt errors there, to the Secretary of a department, to the newly reconstituted Administrative Review Council, a body that looks at and seeks to oversight public administration and improve public administration, and requires the public reporting of the referral and of what action has been taken by those external bodies. So it'll be brilliant in the rare as hen's teeth situation where an individual grievance gets to the tribunal refers it, and then the systemic action is addressed. And that's hardly ever going to occur, which drives home the importance of the AI guidelines that were just referred to a few minutes ago, and the ADM consultation paper that also came out pre-Christmas, which wasn't too bad. It actually didn't reflect the very high vulnerability of human services and social security clients. So, for example, the government discussion paper was proposing to retain protections for third-party proprietary, confidentiality of algorithms and so on, rather than say, as the Royal Commission in its recommendation said, every algorithm used by Centrelink must be made public. So the government paper didn't go as far as it should have in its framework, and it had nothing to say about how it was going to be enforced. It was completely silent. So, I'm not terribly brilliant, but at least some good steps forward. Discussion paper on ADM in government, and as has been mentioned, the Treasurer and the re-elected government is now all about the use of AI and ADM to enhance productivity, and I'm dubious about how many guardrails or frameworks are going to be put in place in the future.
Kate, do you think the government's been transparent about how they're using AI in automation? I mean, have the lessons been learnt? Do we have, or do you have transparency concerns about government's job seeker support system, for example?
We've certainly seen an improvement since the Robodebt Royal Commission and a willingness to engage, particularly in regards to this Centrelink. We still do have really significant concerns around employment services and how automation is being used. And where we, I guess, the issue seems to be really highlighted, as I said before, discretion is a really key part of the social security system. And when discretion is delegated to automated processes, that creates really serious issues. And part of that reason is that at the moment we see, for example, with the TCF glitch I was talking about, there is a bit of a hybrid between human decision-making and automated decision-making. And when you are looking at an issue in terms of administrative review, it's really important to go back to that initial decision maker and to be able to understand why that decision is being made. And that is really difficult. And the consequences of that is that the onus is still on the individual to be arguing against a decision, which is very hard to do if you don't actually understand what the decision is or why it's been made. It also makes it really difficult to provide legal advice because you can't, and we have to go through this complicated system of FOIs, and then how automated systems are, included in FOIs is also an issue.
It becomes hard to challenge things when you don't know what you're challenging. that's the issue, right?
It does. And another thing that we're seeing is that humans, decision makers, are becoming almost like machines themselves. And so they are receiving prompts within the system, and they're not implying the integrity and discretion that they should be. And again, we have seen an example of this, and I want to be really clear. This is different to what I was talking about. This is another 1,000 people who have had unlawful decisions made against them. So in March this year, we had the Secretary of DUA, the Department of Workplace Relations, stand up in Senate estimates and admit that there's been nearly 1,000 unlawful decisions being made, which has resulted in payment cancellations where discretion was not applied. And we're seeing the compensation process of that going through at the moment. As a result of that, they have actually finally they've paused cancellation reduction of payment as a result of this, which is something we've been fighting for a long time. But we are still seeing payment suspensions that occur due to automated processes. And the rate of that, just to give you a perspective, is there has been approximately 200,000 warnings every quarter. And so that is really significant. The stress that creates for individuals. And these are people who just, it happens to them again and again and again. And it really does have a very significant impact.
Mm. Kim, Alex, I think you have an example of transparency deficits in Australian government automation.
Yeah, this was a case with the New South Wales government, which contracted with a private provider to calculate rental subsidies for individuals in the state of New South Wales. And Ms. O'Brien wanted to know how her rental subsidy had been calculated. So she sought that from the state government. She sought access to the source code and how the algorithm operated. And the New South Wales government said, no, this is was provided by our private provider, and it's trade secrecy, commercial confidentiality protected, and we cannot provide that to you. And Ms. O'Brien took it to the New South Wales Civil and Administrative Tribunal, which upheld the government's decision. And it said that disclosure would put the company at a substantial commercial disadvantage, and that the contract between the New South Wales government and the provider only provided for disclosure in the event of bankruptcy. So Ms. O'Brien lost her case and does not know how her rental subsidy was calculated.
Wow. Okay. So a very non-transparent situation there. Kim, does Australia therefore need some sort of AI commissioner or specialised department to deal with these sorts of issues?
Well, on that point that Alex has just raised, can I just refer you back to something Terry said a minute ago, which is that the Royal Commission said that none of these algorithms should be able to be hidden from people. If it's shaping government decision making in a democracy, we have a right to know what is shaping government decision making. And if you don't know what is shaping government decision making, it makes it extremely difficult to contest or even work out if that decision is wrong. Do we need some sort of AI commissioner? There's a whole lot of things we need, right? We need some enforceable rights to challenge some of this that don't just apply in hen's teeth scenarios. There's all sorts of things we need. But to get back to your question, it's actually a really tricky question because, you talk to people in government and they'll say, look, we've got, people in every department who can be responsible for AI in their department, and they really know the domain. You've got someone in Centrelink or social services who will really understand social services and those systems and, can deal with that on a domain-specific level. And then you'll have someone else in agriculture who can deal with it in the agricultural scenario. And you can kind of see this, right? Because whether an AI system is going to work well in a particular domain or is going to be safe or responsible in a particular domain does kind of need some domain expertise, right? What matters in a medical context is different from what matters in a social services context, is different from what matters in an insurance or a banking or, and I could go on. So you can see that argument, which says, actually what we need to do is skill up our existing regulators. and skill up our existing departments and make sure that we've got that. I completely agree. We need to skill up our regulators. We need to skill up our departments. But I think you probably also do need some sort of real central hub that can coordinate this effort and that is responsible for knowing and even being ahead of some of these trends. Because the other thing we are seeing in government is that, each department is kind of doing its own thing, developing its own frameworks, assessing things differently. And when we did the New South Wales Ombudsman report, it seemed, our impression was that often one part of government had no idea what was happening in another part of government. No idea what the systems were, with a learning exercise for everyone. And, I think if we had some sort of, and I don't know exactly what this would look like, we'd have to talk about it, but, some sort of person with responsibility, and some power to direct action, some power to make compulsory the kinds of assessments that we're talking about. And with the responsibility to know and understand and get across systems, and who can, share that knowledge across systems. I actually think that would be some sort of ideal. Another thing that's notable, like just thinking about overseas, right? So Canada has, from its Treasury Department, a directive on automated decision-making that applies across the federal government. It's a system for risk assessment and making sure these things happen safely and responsibly. And one of the differences in Canada was that Treasury had the power to apply this across government. As far as I can tell in the Australian government, there's no one who really has the power to tell every department what it has to do. We have advisory groups like the Digital Transformation Agency, and they provide these these great guidelines, but they can't tell people what they have to do.
Okay, so well, we have an example from Canada, which might offer a useful template for us. How does Australia approach AI regulation? Now, how does it compare to other countries in the world? Alex, I know you worked and studied in the UK for several years. Can you tell us about the UK's AI regulation landscape, and how does it differ from the approach taken in the EU?
Well, the UK is kind of an interesting halfway house, I would say, because it has this legacy of European law. So it has a human rights framework and it has a data protection framework, because at the time, so this is the General Data Protection Regulation 2018, and at the time that it was came into force, the UK was part of the EU, and so it became part of UK law. And that law is mostly about data protection, but it has some automated decision-making specific provisions within it. So you have a right to the meaningful logic of an automated decision, and there's a prohibition on solely automated decisions under Article 22. So those rights currently exist in UK law. But since we've now seen, obviously, the AI Act in Europe, and the UK is not obviously part of that, and we're also seeing what kind of Kim and Terry have been talking about, this move towards innovation. The UK is really desperate to sort of get this Brexit benefit, this Brexit dividend, sort of divergence from the EU. And so not only it's hoping to kind of encourage that AI investment maybe would come to their shores if they have less kind of AI regulation. So not only are they not adopting the AI Act, we're also seeing them watering down the current provisions under the data protection framework. So this prohibition on solely automated decision-making I was talking about, that's going to become only a prohibition where you're using kind of very special data, and otherwise it will be permissible to make a solely automated decision. And that's currently going through the House of Commons.
So, Kim, is it fair to say that we have the UK... So is it fair to say that you have, when it comes to AI regulation, the USA is the most industry positive and perhaps least regulated? Then you have the UK somewhere in the middle. Then that you have the EU, which is more perhaps concerned about consumer outcomes, and maybe Australia, which is yet to tie its colours to the mast. Is that the best way to think about this?
That's not bad, yeah. I think the US is interesting, right? Because, again, prior to the inauguration of President Trump, the US actually had one of the best and most regulatory systems around government use of AI, at least at the federal level, because there was this executive order and Office of Management and Budget memorandum that set out a whole lot of things that federal government agencies had to do. Just to give you one example, the one of those rules, and I can't remember which, made it compulsory for federal government agencies to register their AI systems into a central register. And if you didn't register it, then you couldn't use the system anymore. It would be invalid to use that system anymore, which is, it goes further than just about any other country. Even countries that have like transparency registers like the UK don't have anything like that. So, until relatively recently, there was quite a good system. Or quite a strong regulatory framework there. Of course, President Trump removed that executive order and just about everything else, and has put forward some executive orders that are very much about pursuing US dominance. And the big, beautiful bill includes this very strange little provision that would stop US states from enacting AI regulation. And so there is something of a shift. It's not total. It's actually quite a complicated scenario in the US. Federal government use still has quite a lot of rules around it. It's not a complete free-for-all. But broadly speaking, the US is very pro-AI, pro-US dominance, pro-innovation. Let's pursue this, and let's even stop states from regulating. And then you've got the EU, which has the most comprehensive framework, not fully in force yet. Quite a lot of rules still in development in that space. It's worth noting that that's not the complete picture. We don't really have time today to go into all the details, but South Korea has enacted, a set of rules and risk regulation around AI. Brazil has been operating in this space. China has some really interesting rules. So, we talk a lot about the US and EU, but there's actually a lot more interesting things going on. Singapore has a lot of frameworks. I'm not sure about rules, but they certainly have quite a lot of frameworks, particularly for government uses of AI. So, it is a complicated picture. I think one thing we keep having to come back to, though, is a point that Alex highlighted that I just want to underline, which is, the underlying Australian framework, legal framework, needs development. Our privacy laws need reform. Our administrative laws lack some of these important rights. So privacy law, controls the use of data and processing of data. So, the absence of action on AI is also more problematic in a context where the underlying legal framework is not up to date and does not offer the same protection to Australians as people have in some other countries. Whether it's in corporate or consumer contexts, or privacy law, or administrative law.
A question now for Terry and Kate. Do you think the government currently has the expertise and resources required to use automation lawfully and ethically, even with or without those kind of comprehensive legal frameworks that we need? How much human oversight do these systems need to be balanced with?
I think there always needs to be human oversight if there is a decision that would result in someone's payment being cancelled, reduced, or suspended because of the significant impact on that. I also think that obviously the legal frameworks that both Terry and Kim have talked about is really essential, but what we really need to see is checks and balances in place. It shouldn't take 1,000 people, groups of thousands of people to be impacted, or in the case of Robodebt, tens of thousands of people before there is action. And there also needs to be I guess, regulation or enforcement so that when a department does recognise that there are issues, that there is immediate action taken, that people aren't just sitting on their hands for 2 or 3 years being worried about what the process should be while people are being harmed. And onus shouldn't be on the people that are being harmed to be raising these issues. There needs to be more oversight and regulation that is separate to that.
Terry?
Yeah, it's the curate's egg, really. Looking at now and the foreseeable, perhaps 3 years, the big upside is that the cataclysmic failure of bureaucratic culture, internal bureaucratic standards that the Robodebt Royal Commission nailed at great length and quite appropriately, has led to the bureaucracy, particularly the line departments, social services, NDIA, etc., now being super sensitive to possible risk and consequence. They're almost jumping at their own shadow, and that's brilliant. That the practice is at the moment being driven in a very good direction by that jumping at shadows. But of course, we know that's going to decay, over the foreseeable future. Maybe a couple of years, 3 years, and we'll be back where we were. So the bad side is that there has been no action, and the Robodebt Royal Commission's 17.1, 17.2 recommendations that we've already touched on. They were put, the department that took carriage of those was the Attorney General's department. The discussion paper that they issued, really demonstrated far too little understanding and appreciation of, and one almost wondered whether they'd read about the Robodebt experience. So because what it's clear I, and I think my colleagues here are saying, is we need external frameworks, and we need those frameworks to have teeth of whatever character and how it's going to be, whether it's disseminated within departments or whether it's a single office and so on. And perhaps because, it may even hark back to the inadequate training in law schools of the lawyers the very bright lawyers who go out into, beginning of great careers in departments of attorney generals and other regulatory bodies. That's what worries me most, that there is little appreciation of the need to address the systemic harm, the systemic issues from that high speed, large scale, high impact on vulnerable people systems, particularly in the human services, but not only in the human services. And any justice or redress relies on the systemic remedies. We've fixed, as we've already indicated, the flaws and faults in the individual remedy pathway, but only 1 in 20,000 people traverse that. So we want the remedies that catch and provide speedy enough redress to the 1,999 others, if my math is correct.
Can I just add something, which is that the problem is that where we are means we may be getting the worst of both worlds, right? On the one hand, you have departments and agencies that may well jump at shadows, even when you can do really good things with automation and AI, right? But there are lots of terrific people in government. I've talked to lots of terrific people in government with, great ideas for things they could do that will make services better. And if you live in New South Wales, as I do, you know that actually some of the Services Australia automation has been amazing. There is so much I can do automatically and quickly these days, right? So, we don't want people so jumping at shadows that we can't do anything. But on the other hand, I think people need to have the confidence to know that, if things go wrong, they can be dealt with and quickly, and people know how, and people have confidence that they can step up and point out that there is a problem and we need to deal with it now and it stops now. That sort of 2, 3, that we won't start a system that will harm thousands of people and won't get stopped for 2 or 3 years. So it feels like we're in the worst of both worlds, right? We're going to be super conservative, but then not fix problems when they do arise. What we want is to be less conservative, perhaps, but be able to, foresee and address the problems or deal with them when they arise and quickly.
So I was going to ask a question about what thing worries you most and what thing excites you most, but it sounds like you're saying we're falling between the cracks here. Look, if I can ask each of you very, very briefly to say what excites you most, what thing worries you most when it comes to AI, which can, of course, as Kim points out, do some pretty amazing, wonderful things, and we want to harness the benefits that it can offer. Kate and Alex, if I can get you to offer your thoughts here.
If it's done properly, we can absolutely see that automation and AI could massively assist people access a system that at the moment is incredibly complex, and there are significant barriers to access. So I think that it could be a real game changer for people's ability to equally and fairly access the social security system. I guess a key worry for us is the prioritisation of administrative efficiency over legal compliance and procedural fairness, because that is something that we're seeing government sees a cost-saving measure and is very quick to implement without really thinking about the consequences, and also at a scale in terms of what Kim was talking about as well.
Alex?
In terms of good use cases, I think we're seeing it used to great effect in medicine, being used, for example, to identify kind of the likelihood of having a condition, but then that's something you can sort of then independently verify that prediction with by other means. My concern in terms of AI is I just don't think it should ever be used in a context where you're depriving an individual of a benefit or interest. So I don't think it should be used for granting visas, for social security, for criminal justice. Those areas where you're depriving an individual, I don't think AI is the right approach.
Kim and Terry, briefly.
Thanks. Yes, the positive, and we do overlook the positives, is that AI and ADM has the capacity to provide a genuine answer to poverty and extreme poverty, because it's a multifactorial condition. It's not just income or lack of income. It's got to do with all of those other life experiences and features. And AI, used well, has the capacity to provide what at the moment, for example, at best we have with an area poverty approach of saying a particular region at an aggregate level has high levels of renters or whatever it may be. So AI could be used in a very sophisticated way to more effectively address poverty. The downside, in addition to the one that I've already mentioned, it is where that issue that I touched on early about the fiscal driver of Robodebt. Robodebt was intended. All government efficiency programs of the larger to medium scale are driven by the Expenditure Review Committee of the Cabinet, and the achievement within the portfolio of a saving that can be then utilised for some other good program. And so as a consequence, and that's a fixture, that's never going to change. The political realities and social realities are that that's always going to be the driver. So we're always going to have the prospect of a system being announced in a budget or some other key for the first time. And so the best we can do is ensure that the framework requires the piloting of that program when it's first announced, if it's a large-scale one, because the piloting won't be done before the program is ready to roll out by government. And then secondly, it adds to it accentuates the need for these systemic and other remedies that we've been discussing, because unlike other ADM and AI programs in other contexts where you can have co-design and all the good things prior to the announcement, we're unlikely to ever get as much of that or any of that would be needed to ensure that we had a well-developed system before it was announced.
Kim, a final word from you.
I feel like I've already said it, but just in short, too afraid to regulate, too afraid to innovate, so we end up with crappy technology that we can't fix.
Oh, I think a great way to end our conversation. I think that's all we have time for today. University of Sydney law professor Kimberly Weatherall, former government advisory and a member of the former government advisory IT something. Kate Allingham, the CEO of Economic Justice Australia. Former member of the AAT, Professor Terry Carney, and Alexandra Sinclair. And Dr. Alexandra Sinclair, a recently appointed postdoctoral research fellow at the University of Sydney, and before that worked at the Public Law Project at the UK. Thank you all for a very thought-provoking conversation. Would you please help me thank our guests?